Hello everyone and welcome to today's session, which is Ireland's response to the pandemic. This session is one of a series of interactive webinars hosted by Field Fisher's Employment, Pensions, Immigration and Compliance team, also known as EPIC. We will be hosting a 30-minute session every Tuesday at 1 p.m, covering significant legal developments, hot topics, and offering practical advice for business and organisations in this ever-changing environment. My name is Barry Walsh. I'm an employment law partner in Field Fisher in Dublin, and I will be the main presenter today.
My name is Julie Austin, and I'm also a partner in the employment law team in Field Fisher Dublin, and I will be acting as the moderator of today's session. So if you do have any questions for us during the course of the session, please do let us know using the question box in your control panel, which is located on the right-hand side of the screen. And we'll aim to get through as many questions as possible at the end of today's session. So if you please give us your questions throughout the session, I will then present those to Barry towards the end of the session. If we don't have an opportunity to go through your individual question, we'll follow up immediately after today's webinar. All of our sessions are recorded and they're available to listen in afterwards on the Field Fisher YouTube channel. So I'll hand you back over to Barry to get started on today's webinar.
Thanks very much, Julie. So I know a lot of our audience are in the UK today, and you're likely to see similarities in broad terms between Ireland and the UK in terms of its response to the pandemic. However, there are some differences too, and I'm sure you'll be very interested in these differences, and some of your questions may arise here. So we're very happy to deal with those questions, as Julie has mentioned. Now, a number of topics are going to be covered today, and the first one of these is the Government Temporary Wage Subsidy Scheme, which is Ireland's version of the furlough scheme. We're also going to look at areas such as layoffs, pay cuts, redundancies, and the reopening of the economy and society and the return to work. So these are the general topics we're going to cover one by one today. Just before we do that, some very basic introductory points, which I think are nevertheless important to make. While the term unprecedented has been used a lot, it is very true and very apt in this situation. A lot of us, including very experienced employment lawyers and HR practitioners, have never seen anything like this before. So it is a truly unusual situation, and we've seen things that we probably never thought would happen in a HR environment. It's also very fluid. I think employers and organizations need to stay nimble and flexible and need to be able to change quickly and adapt as needed. It's a very moving situation, and the government here in Ireland are issuing constant updates, tweaking their approach and changing rules slightly as time goes on. So you need to very much to pay attention to what's happening, as there might be some important emphasis and changes in rules from time to time. There's been a very high level of government intervention and guidance in this situation. This is slightly unusual in Ireland. While government obviously passed laws and there are a lot of employment law statutes that employers have to address and deal with, it is at the end of the day a private relationship between employer and employee. And most of the time the state steps back and lets the parties engage in that private relationship. And there's not usually a high level of guidance or prescriptive guidance for employers or organizations. However, in this situation, we've seen a very high level of guidance from the government, and this continues, and we'll talk about that today. Speaking of the government, I think it's fair to say there's a general satisfaction with the role of the government in this situation. And I think business and employers generally feel that the government has done a good job. That might be not a universal view, but I think a high proportion of them feel that it's adapted well and has supported business and will hopefully continue to do so. This pandemic affects all employers, but some more than others. And we see big differences depending on the sector. Obviously, situations like retail and hospitality have been hit very hard. And I note even from news in the UK in recent days that some retailers are under major pressure and are considering a lot of cost-cutting measures. However, other areas, including some of our clients here in Ireland, are less affected. We have a number of tech clients who have not been affected in the same way, at least not in terms of the impact on their business. Other sectors such as pharma and so on will again tell us that they're not affected as much. So it's very much a sector by sector approach depending on where your client is based. Final introductory point is just to say that there is obviously a need for employer and indeed employee flexibility here. Our tribunals are currently closed at the moment. We have employment tribunals in Ireland, just like you do in the UK. The main employment tribunal is called the Workplace Relations Commission, and it deals with probably 95% of normal employer-employee disputes. It hasn't sat officially for a number of months, and while claims continue to be filed by employees, they're not being processed in the same way. It's likely that by the end of the year, most cases will start to come on stream. So a lot of the disputes that are currently arising out of measures being taken by employers will only really come on stream at that stage or maybe early in 2021. However, there may be a day of reckoning for some employers at least. And so the message to employers is to show some forbearance. The employment dispute resolution forums will take a dim view of employers who would be seen to take advantage of the situation and to implement measures that mightn't be fair or might be too quickly imposed. So the need for flexibility and forbearance is an important one. So looking at Ireland's furlough scheme, this is called the Temporary Wage Subsidy Scheme and has been in place since approximately the end of March. At its height, over 54,000 employers in Ireland and over 520,000 employees were participating in this scheme. Now, I've looked at the equivalent figures in the UK, and when you take into account the differences in population and look at it on a pro rata basis, I think it's reasonably similar, although possibly the UK has an even higher proportion of employees who are participating in the furlough scheme. Nevertheless, it's a very significant level of reliance by employers and employees on state subsidy for their salaries. There are some conditions for participation in the scheme. The scheme is administered by the revenue commissioners in Ireland. Now, they're the equivalent of the inland revenue in the UK. So it's administered on the basis of tax and rebates to employers on a monthly basis. One of the main conditions for participation in the scheme is that employers must show a 25% reduction in turnover. As time has gone on, this has become clearer, and the test that the revenue commissioners will apply for employers has become more obvious. At the very beginning of the scheme, a lot of employers were concerned that they might struggle to show a 25% reduction and wondered how they would satisfy this test. However, they were encouraged by the state to participate, and it was indicated that as long as employers participated in good faith, that they would take a relatively straightforward view and would not be unduly onerous. However, there is a clawback mechanism and there is an audit provision in the scheme. And if employers are wrongly participating in the scheme, there may also be a day of reckoning there. And the revenue commissioners have indicated that they will start to carry out audits. And in the last week or so, we know that a number of clients have received communications looking for information to prove their entitlement to participate in the scheme. So certainly would be a nightmare situation for some employers to be hit with tax repayments, which might include interest and so on. And that's the last thing a number of employers want to see. There are other conditions for participation in the scheme. Obviously, the employees have to remain in employment. They don't have to work necessarily. They could be at home and not working, but as long as they remain in employment. And the level of support is quite significant. It's up to 85% of an employee's salary, depending on how much they earn. There is a cap, and it's a tapering measure up to a total of 76,000, meaning that employees who earn more than 76,000 euro will not be able to avail of support. However, all other employees will certainly receive some level of subsidy up to a maximum of 85%. Employers are expected to top up, and indeed, if there are any audits or investigations by the revenue commissioners, they will be asking a number of questions, including whether the employer has topped up from the 85%. It's not mandatory for employers to participate in the scheme. They could choose not to do so. And some employers, for various reasons, have decided not to do so. At the very start, some employers were worried about reputational or publicity reasons. and wondered whether it would affect their reputation if people became aware they were participating in this scheme. That's relevant because all the names of all employers who participate are published on the Revenue website. So anybody can simply click onto the Revenue website and identify which employers are availing of this support. The most important thing, I suppose, about the scheme is it has, at this point, reduced the need for immediate layoffs, redundancies, and pay cuts. So at the very start, society was worried and business was worried generally about the high level of cost cutting that might occur. However, this very significant level of support has reduced the impact at this stage. It's anticipated that support is going to continue at least in the short term. We're receiving regular updates from government, and current indications are that it may exist beyond the summer into the early autumn or mid-autumn, but we'll need to wait and see. Until that happens, we're unlikely to see any massive levels of redundancies, at least at this stage. One of the areas we're going to cover today is layoffs, and I know there's also the practice of layoffs in the UK, and it's broadly similar in Ireland. This is a very useful interim measure for employers who don't wish to terminate the employment of employees at this stage. They're thinking that maybe they might need their employees at some stage over the medium term, and it's not necessary to actually terminate their employment at this stage. However, they may need to cut some costs and may want to place some of their employees on unpaid layoff. Again, the existence of the Temporary Wage Subsidy Scheme has reduced the extent of layoffs, but some employers have still done this, and not everybody has decided to participate in the scheme. The big point about employers who wish to contemplate layoffs is whether there is a contractual clause in the contracts of employment permitting this. We received a lot of queries from employers on this, particularly at the beginning of the pandemic. And we noticed that there's approximately a 50-50 practice, meaning half of the employers have clauses in their contracts justifying unpaid layoff and the other half don't. This is, of course, important. In the absence of a contractual clause, an employer is potentially exposed to a claim under the Payment of Wages Act for an unauthorized deduction of wages by an employee. So an employee could potentially bring a statutory claim to the Workplace Relations Commission, saying that in an unpaid layoff situation, it is in effect a deduction of wages. This is not a strict liability point, and the Workplace Relations Commissioner has a right to take an approach and look at it on a case-by-case basis. Essentially, they're allowed to look at it and say, is it reasonable in all the circumstances for the employer to impose this layoff situation in the absence of a contractual clause? So there's not automatic liability for employers here. And we're hoping that, again, there'll be some level of forbearance showed by the employment tribunal when the time comes. The other important point is that in normal situations, employees who are placed on temporary layoff may, after a period of 4 continuous weeks laid off, or 6 out of 13 weeks, seek a payment of statutory redundancy and may effectively consider themselves to have been dismissed by reason of redundancy and seek that payment from the employer. Ordinarily, this would mean that employers would have to pay out in this situation. The rate of pay is 2 weeks pay per year of service plus a bonus week, but that's capped at €600 per week, and it's only available to employees who have more than 2 years service. So for example, an employee with 5 years service could be entitled to €6,600 for statutory redundancy. That's the usual rule. However, in this situation, this rule has been removed for the course of the pandemic, which is a great source of relief to many employers. We're also going to talk about pay cuts. There's no statutory process for pay cuts in Ireland. Most of this is done on the basis of best practice or good HR practice. Now, a lot of employers in Ireland turn to consider pay cuts in situations like this. We saw a lot of this back in the economic recession in 2008. And so it's been a long time since there was a huge number of pay cuts in Ireland. But this has come back on the agenda in more recent months, and a lot of employers are considering this. We also know that this has occurred quite extensively in the UK in some cases. Now, one of the big differences between Ireland and the UK here is that a lot of Irish employers don't formally seek express contractual consent. We know in the UK that a lot of the approach is sometimes to seek express consent. In Ireland, a lot of employers go for more of a pure notification model, or at least walk a middle line between pure notification and actually seeking consent from their employees. So in many cases, Irish employers are reluctant to seek express consent for fear that it won't be received, and they decide instead to engage in an information and notification exercise, consulting to the extent they can with employees, but ultimately imposing the pay cuts without obtaining contractual consent. The extent of these cuts typically tends to be between 10 and 20%. In some cases, we will see higher levels of pay cuts, such as 30 or 40%, but they would really be the exception. And most of the time, it goes no further than 20%. The duration of the cuts is also important. Again, in most cases, we see cuts that might only last for 3 or 4 months, perhaps, and not any longer than that. Just like in the layoff situation, these deductions or reductions of wages could constitute an unfair deduction of wages under the Payment of Wages Act, and employees could consider an unauthorised deduction claim under that legislation to the Workplace Relations Commission. As I mentioned a little earlier, the Workplace Relations Commission is effectively largely closed at the moment and is not processing claims in the normal way. There are only a small number of remote hearings occurring, and there's no in-person hearings occurring at this moment. And while that's coming on stream, as I said, it will be the end of the year or early next year before most of these claims are heard. So there is a level of uncertainty as to how the Workplace Relations Commission will deal with unilateral pay cut situations. Again, it's not a strict liability or an automatic liability situation for employers. The tribunal is entitled to look at it and decide whether it was reasonable in all the circumstances for the employer to impose the cut. Relevant factors in situations like this will be the duration of the cuts and the extent of the cuts, and of course the extent of consultation engaged in with employees before the cuts were imposed. In more extreme cases, you might see constructive dismissal claims in Ireland, where the pay cut is excessive and so significant that it wouldn't be reasonable to expect the employee continue in their employment. They're relatively rare, and most of the challenges are on the Payment of Wages Act instead. So it'll be very interesting to see how these claims pan out. Some of the points that the tribunal will take into consideration is whether the employer participated in the Temporary Wage Subsidy Scheme and how relevant it really was, or how important it really was to impose the cut in the first place. In terms of redundancies, you'll obviously be very familiar with redundancies in the UK and the usual process that is followed in redundancy situation. I think you'll find broad similarities between Ireland and the UK when it comes to redundancies. And over the years, we've had the opportunity to engage extensively with UK HR and employment lawyers, and we've noticed that there are these broad similarities. Essentially, you'll have your two-step test in that you'll have to show a business justification or an economic justification, as well as a fair process before any redundancies can be carried out. And looking at your business case, you'll obviously have to show that they are genuine redundancies and are actually required, that they're not opportunistic dismissals in circumstances for employees that the employer may be unhappy with or may want to dismiss for other reasons. You'll also have to consider whether it's a collective redundancy, and there are thresholds that apply over which it is necessary for the employer to carry out a collective process. This will slow down the process by at least 30 days because there is a 30-day collective consultation obligation in these situations. There's also notification to government ministers and the requirement to elect employee representatives and engage in group consultation. This seems to put off a lot of employers, and some employers will massage figures sometimes or look at time periods or the exact numbers that needed to be made redundant in order to avoid this obligation. You'll also see familiar notions like selection and selection matrix, which I'm sure you'll also see in the UK in these situations. Redundancy pay in Ireland tends to be reasonably generous. On top of the statutory redundancy figure that I referred to earlier, you often see enhanced or ex gratia redundancy pay. The formula for payment tends to differ widely between sectors and between employers. It's hard to know what the absolute average is, but it would not be unusual for payments like 3 weeks' pay per year of service, and often much higher, to be made to employees. Custom and practice is very relevant here, and employers or industry sectors that are typically generous in these situations would have higher enhanced redundancy payments. We would always seek a waiver or a compromise type agreement in this situation where enhanced payments are made. This is important because redundancies, if not carried out correctly, can lead to unfair dismissal claims. In Ireland, an employee only needs 12 months service to take an unfair dismissal claim, which I understand is shorter than in the UK. Also, the cap on redundancy payments, the cap on unfair dismissal awards in Ireland is much higher than in the UK. And payments of up to 2 years remuneration compensation awards by the tribunal can be made. That's a very high level of payment. And while typical payments aren't normally as high as that, the potential is there. And it's very important for those reasons that employers try and obtain waivers or compromise agreements in situations where they're offering enhanced payments. And this is always the priority of employers when imposing redundancies. In terms of return to work, we're now seeing a return to work in many industries, slowly but surely. It's important to say that remote working or home working in Ireland, while it obviously existed in some cases, wasn't very extensive prior to the pandemic. However, in the mid or late March of this year, huge numbers of employers decamped and employees left for home with their laptops and so on, just like they did in the UK. The perception is that this actually worked very well and it was very successful in most situations. So employers who are worried about home or remote working are satisfied with how this has gone, and it's been a very successful outcome overall. However, there's no general right to home working or to remote working, and this may lead to disputes later in the year when most employers are applying pressure for the majority of their employees to return to work, and we'll look at that in a moment. I mentioned the very high level of government guidance and intervention, and here the government has worked very hard and has issued a high number of frameworks and guidances for employers and organisations. Overall, the Irish government has taken a somewhat cautious public health approach over business. Now, it'll be interesting to see how long this lasts, particularly as the economic recession continues to bite and economic pressure increases. However, to date, it's certainly continuing with this public health approach. Some of the key documents to look out for are what's called the Government Roadmap for Reopening Society and Business. This is generally referred to as the roadmap. This initially had 5 phases, but this has accelerated over time. And we've noticed that the government is speeding up the return to work in many situations. There's also a government national return to work safety protocol, referred to as the Health and Safety Protocol. This is, as the name suggests, more a health and safety document. And combined with this, the Irish Health and Safety Authority has issued a significant number of standard forms and templates for employers. And this is great, very useful, practical guidance for employers who want to reopen the workspace, but to do so safely and to encourage employees to return on a voluntary basis. All sorts of areas like control tracing, tracking, temperature testing, and return to work forms have been imposed and are being widely used by employers. So there's a lot of information available, which is a result of hard work by a lot of government institutions. We do expect, nevertheless, that there will be disputes later in the year between employers and employees in certain situations where employees refuse to return to work for whatever reason. This might be as a result of childcare concerns or health concerns, or simply because some employees prefer working at home and find it far more beneficial or efficient. This remains to be seen, but again, we're urging employers to be as sensible as possible and as flexible as possible in these situations and to avoid disputes if possible. Ultimately, when returning, employers will need to ask, is the workplace safe? And are employees returning on consent? They're not legally obliged to have it on consent, but ideally this would be desirable to prevent disputes arising. So some closing thoughts on this. The best practice advice for all employers is to apply the usual good practice test of the reasonable employer. You should follow government guidance, should be flexible and engage, inform and consult where possible with your employees. Complaints and questions should be dealt with as quickly as possible. And if you have an employee assistance program, which I'm sure many of you will have, employees should be reminded of the existence of this program. Many employees might be struggling due to isolation and home working problems, and certainly access to an EAP will be very helpful and may prevent liability as well as keeping your employees happy. And finally, while obviously people hope there won't be a second wave, employers will have learned a lot over the last 6 months. As I said, things have happened that they probably never anticipated would ever happen in the workforce. And employers need to learn from this and be ready for the future if similar things occur again. Julie, I wonder, do you have any questions that you'd like to put to me resulting from our audience feedback?
Yes, we have a few questions in. One question that is on a lot of people's minds is when the wage subsidy scheme is going to come to an end in Ireland. So is there any clarity from the government on when the wage subsidy scheme is going to come to an end?
Okay, thanks for that, Julie. Well, it's certainly lasting longer than we anticipated. When it came out first, we thought it would be only a matter of 2-3 months, but it gets extended and extended. Current indications, which are tentative enough from the government, suggest it might continue on until the autumn, earlier mid-autumn. That might change quickly, but certainly there's a lot of political and economic pressure for the scheme to continue as long as possible.
Okay. And another question, we haven't seen very many redundancies yet in Ireland, unlike in the UK, where a number of large-scale redundancies have been announced. We presume that that is linked to the fact that the wage subsidy scheme is going to be continued in Ireland. Would that be also your assessment of the situation in Ireland?
I think that's right, Julie. I think the temporary wage subsidy scheme has kept a lot of employers afloat, and I think employers feel that it's not economically necessary at this stage to make any redundancies. So I think that large scale cost cutting that we fear hasn't happened yet. Hopefully it won't, but if it does happen, it's likely to be later in the year after the scheme ends. We haven't seen extensive numbers at this stage.
Okay. Another question coming in just in relation to temperature testing, which you mentioned earlier. Some employers are looking to introduce temperature testing in the workplace. Is that something that's permissible in Ireland?
It's not permissible at this stage, except in what you might call safety critical environments. But for your average workplace, and certainly say for your average office environment, it's not anticipated or permissible at this stage. Now that might change, and the government does have the power to make it mandatory, or at least to allow employers to do it. But certainly the Data Protection Commissioner, which is the equivalent of the ICO in the UK, guidance from the Data Protection Commissioner at this stage is suggesting that it shouldn't occur except in these safety critical environments. So we're seeing very little of that in most cases.
Okay. Another question coming in relation to the wage subsidy scheme. So is it possible to make people redundant while they're on the wage subsidy scheme?
Yes, it is. I mean, there's no actual bar on redundancies. Employers who are participating in the scheme but feel that they need to impose redundancies can do that. And I think one of the big issues there is at what point should the employer cease the support or cease availing of the subsidy. And certainly guidance would appear to be that as soon as the employer knows that it's going to impose the redundancies, it should stop availing of the subsidy to avoid any risk of a clawback in the future. So certainly at the point at which it's actually issuing redundancy notice, say for the notice period, it shouldn't avail of that subsidy. But yes, but there's no bar to redundancies per se, just because you're participating in the scheme.
Okay, so we have 1 minute left, so we'll take one last question. If anyone does want to submit questions, we will answer them after the webinar. But the last question that I'll take is, if employees do bring an unfair dismissal claim in Ireland, is there any major difference between the levels of awards that can be made in Ireland versus the awards that can be made in the UK?
I think certainly anecdotally, Julie, and based on our experience, and I know my experience and your experience over the years, is that Ireland is considered to be probably a more generous environment for compensation awards for unfair dismissal. As I mentioned, up to 2 years remuneration can be paid as a compensation award, and while amounts of that size are probably relatively rare, it's not unusual by any means to see awards of 9 months or a year or something like that. And certainly our experience over the years is that it is a more generous environment for employees in Ireland compared to the UK.
Okay, that brings us up then to the 30-minute mark. So we won't take any more questions for now. But as I said, if anybody does want to submit a question after today's session, we can follow up individually afterwards.
Okay, thanks, Julie, and thanks to everybody who listened in today. And as Julie said, we'd be very happy to assist with any follow-up questions people have. Thank you very much, and good afternoon to all.